Good day, everyone. Welcome again to the series of lectures on civil procedure. Our topic for today is Rule 10, which deals with amended and supplemental pleadings. Can pleadings be amended? Pleadings may be amended as a matter of right, or it may require prior leave of court. Okay, how do you amend pleadings? Pleadings may be amended by adding or striking out an allegation or the name of any party, or by correcting a mistake in the name of a party, or a mistaken or inadequate allegation or description, so that the actual merits of the controversy may speedily be determined without regard to technicalities in the most expeditious and inexpensive manner. Okay, so as a general rule, amendments may be made. Any change in the pleadings, okay, may be the subject of an amendment. Either you want to add to it or you want to delete something from it. Okay. Now, amendments may be a matter of right, or it may be by leave of court. Okay. When are amendments considered as a matter of right? A party may amend his pleading once as a matter of right at any time before a responsive pleading is served, or in the case of a reply, at any time within 10 calendar days after it is served. Okay, so from the uh, from the time that the summons is served and no answer has yet been filed, okay, the plaintiff enjoys the right to amend his complaint as a matter of right. On the other hand, if an answer was filed and served, and there is an actionable document, for example, which was filed in the answer, okay, the dependent at any time before a reply is served, okay, enjoys the right to amend the answer as a matter of right. So before a responsive pleading is served, amendment is a matter of right. In a third-party complaint, the same is true. When the third-party defendant has not yet filed or served his answer, then the third-party plaintiff enjoys, as a matter of right, the right to amend the third-party complaint. Amendments may also be by leave of court, meaning you have to seek permission from the court before you can amend your pleading. Substantial amendments may be made only upon leave of court, but such leave shall be refused if it appears to the court that the motion was made with intent to delay or confer jurisdiction on the court, or the pleading stated no cause of action from the beginning which could be amended. Okay, so amendments, once the issues have already been joined. So meaning, once there is already a responsive pleading that was filed, okay, amendment becomes a matter of discretion upon the court. Meaning, permission from the court must first be obtained before one can amend your pleading. For example, a complaint, an answer to the complaint has already been filed, and the plaintiff wants to amend his complaint. Amendment in that case, okay, has to have permission from the court. The permission will not be granted if what was the amendment that is sought to be introduced is a substantial amendment. And the motion was made either with intent to delay, to confer jurisdiction on the court, or to plead a cause of action when there was none in the beginning. Okay. How about formal amendments? What are those formal amendments? A defect in the designation of the parties and other clerical or typographical errors may be summarily corrected by the court at any stage of the action, at its initiative or upon motion, provided that there is no prejudice caused to the adverse party. So with respect to formal amendments, it can be made at any time, okay, during the action. Okay, either motu proprio or upon motion of the party, provided that there is no prejudice caused to the other party. Unlike substantial amendments, if the issues have already been joined, there was already a responsive pleading filed, you have to first seek permission from the court. The court will deny leave of court if, for example, the motion was intended to delay, or it is meant to confer jurisdiction on the court, or if it is if the pleading in the beginning stated no cause of action. Okay. When any pleading is amended, a new copy of the entire pleading incorporating the amendments, which shall be indicated by appropriate mark, shall be filed. So the amended ones, okay, the amended portion will be highlighted either by underscore or by italics or by making it bold. Okay. Now, what is the effect of amendment in the pleading? An amended pleading supersedes the pleading that it amends. However, admissions in superseded pleadings may be offered in evidence against the pleader, and claims or defenses not incorporated in the amended pleading shall be deemed waived. So you must remember that when you file an amended pleading, it replaces the original. Okay, however, the original, okay, can be offered in evidence against the pleader. Okay. When issues not raised in the pleadings are tried with the express or implied consent of the parties, they shall be treated in all respects as if they have been raised in the pleadings. No amendment of the pleadings is necessary to cause them to conform to the evidence. So you must always remember that in the introduction of evidence, you must not allow the other party to introduce evidence which is not part or which was not raised in his pleadings. If you do so, then it is not needed and evidence is introduced on a matter which is not raised in the pleadings. Then it becomes part of the records and there is no need to amend the pleadings in order for it to conform to the evidence. What are the kinds of amendments? First, adding an allegation or the name of any party. Second, striking out an allegation or the name of any party. Third, correction of a mistake in the name of a party or a mistaken or inadequate allegation or description. What is the purpose of amendment of pleadings? So that the actual merits of the controversy may speedily be determined without regard to technicalities in the most expeditious and inexpensive manner. How is an amendment made? A pleading is amended by filing a new copy of the entire pleading incorporating the amendments and indicated by appropriate marks, usually by underline, bold, or italics. What is the effect of an amended pleading? The amended pleading supersedes the pleading that it amends. However, admissions in the original pleading may be received in evidence against the pleader. Amendment as a matter of right. Again, at any time before a responsive pleading is served, the original pleading may be amended as a matter of right. In case of a reply, within 10 calendar days after it is served but before receipt of the rejoinder. In cases where an amendment is a matter of right, leave of court need not be filed. It is the ministerial duty of the court to admit the same. So once the issues have not yet been joined, meaning there is no responsive pleading served yet, you can still change or alter your pleading. You don't need to seek permission from the court. You just file an amended pleading. Okay. A motion to dismiss is not considered a responsive pleading. An answer is also a pleading, thus the same can be amended once as a matter of right before the reply is served. Formal amendments may be made summarily, motu proprio by the court or on motion at any stage of the action, provided that there is no prejudice caused to the adverse party. What are the kinds of formal amendments? Defect in the designation of the parties and clerical or typographical errors. Let us now go to the cases. We have Uwico versus Urami. In this case, stockholders of Stradec executed pledge agreements where they pledge a certain amount of their stocks in favor of Urami to secure the loan obligations of Stradec to Urami. A public auction sale was held of the pledged stocks. Now, more than a year later, Urami, which until then was not able to file an answer, filed with the RTC a motion for leave to file an answer. The Court of our rules of procedure allow a party to amend his pleading as a matter of right, so long as the pleading is amended only once and before a responsive pleading is served. Otherwise, a party can only amend his pleading upon prior leave of court. Courts are impelled to treat motions to amend pleadings with liberality. This is especially true when motion for leave is filed during the early stages of the proceedings. As long as it does not appear that the motion for leave was made with bad faith or with intent to delay, courts are justified to grant leave and allow the filing of an amended pleading. In this case, Urami filed its motion seeking the admission of its amended answer more than 2 years after it filed its original answer. Despite the considerable lapse of time between the filing of the original answer and the motion for leave, the RTC still granted the motion. Such grant was later on affirmed by the CA. The allowance of Urami's amended answer is in order. To our mind, the consideration of the evidence that Urami plans to present during the trial reveals that the admissions made by Urami under its original answer were a product of a clear and patent mistake. Urami should be given a chance to file its amended answer in order to rectify such mistake. The amended answer aims to correct certain allegations of fact in the original answer, which are crucial to a full and proper disposition of the case. It is therefore in the best interest of justice and equity that Urami should be allowed to file an amended answer. Triviana versus Triviana. In this case, Lourdes filed a petition for habeas corpus, claiming that her husband left their conjugal home with their daughter. Now, Edwin moved to dismiss the petition on the ground that the petition failed to allege that earnest efforts at a compromise were made before its filing. Remember that when it comes to suit between members of the same family, you must allege in the complaint that earnest efforts were exerted to settle the case, but it failed. The failure of a party to comply with a condition precedent is not a jurisdictional defect. Such defect is curable by amendment as a matter of right without leave of court if made before the filing of a responsive pleading. A motion to dismiss is not a responsive pleading. So considering that in the case of Triviana, what he filed is a motion to dismiss and not an answer, the issues are deemed not to have been joined, and therefore, the plaintiff enjoys the right to amend his pleading as a matter of right and to submit an amended complaint. In cases where the defect consists of the failure to state compliance with a condition precedent, the trial court should order the amendment of the complaint. Court should be liberal in allowing amendments to pleadings to avoid multiplicity of suits and to present the real controversies between the parties. We have the case of Guntalili versus De La Cruz. In this case, De La Cruz filed a complaint for quieting of title against Guntalili. Petitioner and his co-defendants moved to dismiss on the ground that the complaint stated no cause of action. Respondent filed a motion for admission of an amended complaint with attached amended complaint. A party to a civil case is precisely given the opportunity to amend his pleadings to correct the mistakes. In this case, the complaint was amended even before the petitioner could file any responsive pleading, and therefore amendment is a matter of right. Okay, we have the case of Remington Industrial Sales versus CA. So in this case, the petitioner filed a complaint for sum of money and damages against Industrial Steels. ISL moved for the dismissal of the complaint on the ground that it failed to state a cause of action. Now, Remington sought to amend its complaint by incorporating additional factual allegations constitutive of its cause of action. Okay, in the Remington maintained that it can amend the complaint as a matter of right because no responsive pleading has yet been filed. Can a complaint still be amended as a matter of right before an answer has been filed, even if there is a pending proceeding for its dismissal before the higher court? The Supreme Court said this only means that prior to the filing of the answer, the plaintiff has the absolute right to amend the complaint whether a new cause of action or change of theory is introduced. Substantial amendment is not allowed without leave of court after an answer has been served because any material change in the allegations could prejudice the right of the defendant who has already set up his defense in the answer. The defendant still retains the unqualified opportunity to address the allegations against him by properly setting up his defense in the answer. Considerable leeway is given to the plaintiff to amend his complaint once as a matter of right prior to the filing of the answer by the defendant. The right granted to the plaintiff under procedural law to amend the complaint before an answer has been served is not precluded by the filing of a motion to dismiss. Amendment of pleadings is favored and should be liberally allowed in the furtherance of justice in order to determine every case on the merits without regard to technicalities. This principle is recognized to speed up trial and save party litigants from incurring unnecessary expense so that a full hearing on the merits may be had and multiplicity of suits may be avoided. Let us now go to amendments with leave of court. After service of the answer, the issues are already joined. Amendment becomes a matter of discretion upon the court. Meaning, before you can file, before you can amend your pleading, you have to seek permission from the court. Amendments of substantial matters can only be made with leave of court, notice to the adverse party, and opportunity to be heard. However, there are limitations on the court's discretion in allowing substantial amendments. Amendments will be denied in the following cases: when the motion was made with intent to delay, when amendment was made to confer jurisdiction on the court, when the original pleading stated no cause of action from the beginning, which could be amended. Now, what are the requirements for substantial amendment of pleading after a responsive pleading has been filed? Okay, first, there must be leave of court to admit amended pleading. Second, there must be notice to the opposing party. And third, there must be a hearing of the motion where the adverse party will be given the opportunity to oppose or comment on the motion. We have the case of Lee Sam versus BDO. In this case, the petitioners filed a complaint against the respondent for annulment of mortgage. The spouses Soriano, in their personal capacity and for their own use and benefit, obtained a loan from the defendant PCIB using the said realty as collateral. However, the spouses Soriano did not secure board approval for the mortgage of the realty. Spouses Soriano filed an answer stating that they were duly authorized by Lisam to mortgage the property. The proceeds of the loan were used for the benefit of Lisam. PCIB filed a motion to dismiss on the ground of lack of legal capacity to sue. While awaiting resolution of the motion for reconsideration, petitioners also filed a motion to admit amended complaint, amending paragraph 13 of the original complaint. The trial court ruled that the amended complaint can no longer be admitted because the same absolutely changed petitioner's cause of action. Now, the issue is whether or not the court committed error when it denied the admission of the amended complaint filed as a matter of right after the order of dismissal was issued, but before its finality. A responsive pleading having been filed, it should be noted that respondent already filed an answer. A responsive pleading having been filed, amendments to the complaint may only be made with leave of court and no longer as a matter of right. Okay, even if the amendment substantially alters the cause of action, such amendment could still be allowed when it is sought to serve the higher interests of justice, prevent delay, and secure a just, speedy, and inexpensive disposition of actions and proceedings. Amendments to pleadings are generally favored and should be liberally allowed to further justice, be determined on its real facts, and in order to speed up the trial or prevent the circuitry of action and unnecessary expense. Amendments are generally favored. It would have been more fitting for the trial court to extend such liberality towards petitioners by admitting the amended complaint which was filed before the order dismissing the original complaint became final and executor. Doing so would have served the higher interests of justice, as this would provide the best opportunity for the issues to be truly, thoroughly threshed out and the rights of the parties finally determined. We have the case of CBBL versus Banco Filipino. So in this case, Banco Filipino filed a motion to admit amended or supplemental complaint, okay, seeking to substitute CB for the defunct central bank and its monetary board. Now, the RTC granted the motion to admit. More than 10 years from the enactment of Republic Act 7653, Banco Filipino again filed a motion to admit a second amended or supplemental complaint. Respondent seeks to include the Bangko Sentral and its monetary board as additional defendants. It questioned the propriety of the RTC's order admitting Banco Filipino's second amended complaint. The issue is whether the RTC erred in admitting Bangko Pilipino's second amended supplemental complaint. In this case, the causes of action subject of the second amended complaint only arose in 1994, well after those subject of the original complaint. The original complaint was based on the alleged illegal closure of Bangko Filipino effected in 1985. Since the acts or omissions committed in violation of the respondent's rights are different, they constitute separate causes of action. The acts complained of cover not just the conservatorship, receivership, closure, and liquidation of Bangko Filipino, but also the alleged acts of harassment committed by the BSP after the respondent bank was reopened in 1994. These acts constituted a whole new cause of action. If it is admitted, the RTC would need to look into the propriety of two entirely different causes of action. This is not allowed by law as explained in the preceding paragraphs. Okay, a supplemental pleading only serves to bolster or add something to the primary pleading. Its function is to set up new facts that justify, enlarge, or change the kind of relief sought with respect to the same subject matter as that of the original complaint. A supplemental complaint must be founded on the same cause of action as that raised in the original complaint. A supplemental pleading technically states a new cause of action should not be a bar to its allowance. Still, the matter stated in the supplemental complaint must have a relation to the cause of action set forth in the original pleading. However, in this case, Bangko Pilipino, to the second amended complaint, attempted to raise new and different causes of action that arose only in 1994. These causes of action had no relation to the causes of action in the original complaint, as they involve different acts or omissions, transactions, and parties. If the court admits the second amended complaint, there will be no end to the process of amending the complaint. For these reasons, whether viewed as an amendment or supplement to the original complaint, the second amended complaint should not have been admitted. We now move to the case of Chu versus PBCom. So in this case, Asian Water Resources, AURI, applied for a real estate loan with PBCom to fund its purified water business. Now, as security, they executed a real estate mortgage. PBCom filed a complaint for collection against the petitioners. Petitioners filed their answer alleging that they were not personally liable on the promissory notes because they signed the surety agreement in their capacities as officers of AURI. They claim that the surety agreement were falsified, considering that when they signed the same, the words "in his personal capacity" did not yet appear in the document, and it was merely intercalated without their knowledge and consent. Now, PBCom filed a reply and answer to counterclaim with motion for leave to substitute Annex A, wherein it attached the duplicate original copy retrieved from the file of the notary public. Invoking liberal interpretation, it emphasized that the motion incorporated can be treated as a motion for leave of court to amend and admit the amended complaint. So the RTC allowed the substitution of the altered document with the original surety agreement. PBCom contended that since the complaint is based on an actionable document, the surety agreement, the original or a copy thereof should be attached to the pleading. Considering that the surety agreement is annexed to the complaint, it is an integral part, and its substitution with another copy is in the nature of a substantial amendment, but with prior leave of court. Okay, however, this court found that the RTC did not err in allowing the substitution. The amendment may substantially alter the cause of action or defense. This should only be true, however, when despite substantial change in the cause of action, the amendment sought shall serve the higher interests of justice, prevent delay, and secure a just, speedy, and inexpensive disposition of the case. Even if the amendment, in this case, there was no fraudulent intent on the part of PBCom in submitting the altered surety agreement. The bank admitted that it was a mistake on their part to have submitted it instead of the original agreement. It also admitted that through inadvertence, the copy that was attached to the complaint was the copy wherein the words in his personal capacity were inserted to conform to the bank's standard practice. This alteration was made without the knowledge of the notary public. PBCom's counsel had no idea that what it submitted was the altered document, thereby necessitating the substitution of the surety agreement with the original in order that the case would be judicially resolved. We have the case of PNB versus Manalo. In this case, Manalo applied for an all-purpose credit facility with PNB to finance the construction of their house. After PNB granted the loan, they executed a real estate mortgage in favor of PNB. After Manalo failed to settle the loan, PNB foreclosed the mortgage. The spouses Manalo instituted this action for the nullification of foreclosure proceedings. Okay. However, they modified their position and claimed that the loan document executed were contracts of adhesion, which were null and void. They also questioned the interest rates and the penalty. However, considering that the bank did not interpose any objection to these matters being made part of the plaintiff's evidence, so much so that their memorandum contained discussions rebutting these arguments on these issues, the court must necessarily include these matters in the resolution of the case. The issues were impliedly raised during the trial itself, and PNB's lack of vigilance in voicing out a timely objection made that possible. It appears that Manalo's judicial affidavit introduced the issues of the validity of the interest rates and the lack of mutuality between the parties. PNB cross-examined Manalo on his judicial affidavit. There is no showing that PNB raised any objection in the course of the cross-examination. Consequently, the RTC rightly passed upon such issues. The plaintiff, without objection, introduced sufficient evidence to constitute the particular cause of action which it intended to allege in the original complaint, and the defendant voluntarily produces witnesses to meet the cause of action. Thus, issues have been joined as if it had been previously joined by the most perfect pleadings. So even if the issues were not raised in the pleadings, if the same was introduced in evidence and there was no objection on the part of the opposing party because he participated in the proceedings, then the court can rule upon those issues even if they were not raised in the pleadings. Although the pleading may not have been amended to conform to the evidence, judgment may nonetheless be rendered, not simply on the basis of the issues alleged, but also on the basis of the issues discussed or facts proved in the court in the course of the trial. We now go to supplemental pleadings. What are supplemental pleadings? Upon motion of a party, the court may, upon reasonable notice and upon terms that are just, permit him to serve a supplemental pleading setting forth transactions, occurrences, or events which have happened since the date of the pleading sought to be supplemented. The adverse party may plead to the supplemental pleading within 10 days, calendar days, from notice of the order admitting the supplemental pleading. Remember, supplemental pleading refers only to transactions, occurrences, or events which happen since the date of the pleading sought to be supplemented. It is always with leave of court. Okay? The filing of a supplemental pleading is always with leave of court. Now, what is the effect of a supplemental pleading? It serves to bolster or add something to the original pleading. It exists side by side with the original and does not replace but merely supplements the same. It is a continuation of the original pleading. Unlike in amended pleading, it supersedes the original. In supplemental, it adds to or continues the original pleading. Okay. Raising of a new cause of action. A supplemental pleading may raise a new cause of action as long as it has some relation to the original cause of action in the original complaint. In the event that new matters are alleged in the answer and the plaintiff wishes to interpose any claims arising out of the new matters, such claims shall be set forth in an amended or supplemental complaint. Okay, so if you want to contest the new matters alleged in the answer, then you can do so by an amended or supplemental complaint. Answer to a supplemental pleading must be submitted within 10 days from receipt of the order admitting the supplemental pleading. We have the case of Young versus C. A supplemental pleading serves to bolster or add something to the primary pleading. They exist side by side with the original. It does not replace that which it supplements. It is a continuation of the complaint. Its usual office is to set up new facts which justify, enlarge, or change the kind of relief with respect to the same subject matter as the controversy referred to in the original complaint. The purpose of the supplemental pleading is to bring into the records new facts which will enlarge or change the kind of relief to which the plaintiff is entitled. When the cause of action stated in the supplemental complaint is different from the causes of action mentioned in the original complaint, the court should not admit the supplemental complaint. The parties may file supplemental pleadings only to supply deficiencies in or aid of an original pleading, but not to introduce new and independent causes of action. In this case, the consolidation of title over the property are new matters that occurred after the filing of the original complaint. The relief prayed for in the supplemental complaint, which is the exercise of the right of legal redemption accorded to co-owners of property, is germane to and intertwined with the cause of action in the complaint for the nullification of the second supplemental to the extrajudicial partition. Unless the partition is nullified or declared without any force or effect, the petitioner will not be considered a co-owner of the property and she will be unable to exercise any right of legal redemption. The evidence required to prove petitioner's right of legal redemption in the supplemental complaint will be exactly the same evidence required to prove the nullification of the partition in the complaint. Lastly, we have the case of Ada versus Bailon. So in this case, the complaint was filed by the petitioners with the RTC involving two separate and independent actions, partition as well as rescission. There was a misjoinder of causes of action. The action for partition filed by the petitioners could not be joined with the action for rescission of the said donation. As A supplemental pleading serves to bolster or add something to the primary pleading. A supplement exists side by side with the original. It does not replace that which it supplements. A supplemental pleading may properly allege transactions or events which transpired after the filing of the pleading sought to be supplemented. While a matter stated in the supplemental complaint should have some relation to the cause of action in the original pleading, the fact that the supplemental pleading technically states a new cause of action should not be a bar to its allowance, but only a matter that may be considered by the court in the exercise of its discretion. We stress that a broad definition of cause of action should be applied. Here, the issue as to the validity of the donation inter vivos made by Rita in favor of Florante is a new cause of action that occurred after the filing of the original complaint. However, the petitioner's prayer for the rescission of the donation in their supplemental pleadings germane to and intertwined with the cause of action in the partition case. The petitioner's supplemental pleading merely amplified the original cause of action on account of the gratuitous conveyance after the filing of the original complaint and prayed for additional reliefs, rescission. Indeed, the petitioners claim that said lots form part of the estate of Bailon but cannot be partitioned unless the gratuitous conveyance is rescinded. Thus, the principal issue raised by the petitioners in their original complaint remained the same. So that's it for Rule 10, amended and supplemental pleadings. Thank you for listening and don't forget to subscribe.